Welcome to another Talking Feds one-on-one, which is different from our normal one-on-ones in two ways. First, it's not a one-on-one. It's a one-on-two, as you'll shortly hear. And then second, whereas we normally dive into the substance of an issue, here I thought we have a really great opportunity to have two participants in a recent hearing in the House kind of describe that whole process that begins when a member of the majority, say Jim Jordan, calls for a hearing that obviously seems to have a political agenda to it. Anyway, that's what I hope we can discuss today. And we have two great, a witness and a member of Congress from a hearing last week. And they are Kate Shaw, a constitutional law scholar at Penn, Carey Law. Her work focuses on executive power, democratic governance, the Supreme Court, and reproductive rights. And she has extensive government experience, including in the executive branch and clerking for Justice John Paul Stevens. She's also a prolific public commentator, the Strict Scrutiny podcast, and ABC, and others. So, Kate Shaw, thanks so much for being here.
Thanks so much for having me, Harry.
And Congresswoman Mary Gaye Scanlon, who represents and is currently at Pennsylvania's 5th Congressional District. She serves on the House Committee on Rules and the House Judiciary Committee. She's the ranking member of the subcommittee on the Constitution and Limited Government. I always like she's been great about being a friend to the podcast and appearing. Before her election to Congress, she was an attorney at the Education Law Center, a great local organization in Penn. I guess it might be one of the 10,000 that are now threatened by the NGO order. We're all biting our nails waiting to come out. But she was also president of her local school board, co-chair of the Voting Rights Task Force of the Association of Pro Bono Counsel. But to me and Kate, she would be Congresswoman Mary Gaye Scanlon. Thanks so much for joining us.
Thanks for having me back.
Okay. I think we can set the stage pretty easily. The House Judiciary Committee on Courts, Intellectual Property, Artificial Intelligence, and the Internet, but the Subcommittee on the Constitution and Limited Government held a joint hearing, it was a few weeks ago now, to examine the constitutional limits of the judicial power with a focus on recent temporary restraining orders. So it didn't take too much deciphering to know that this was Jim Jordan and others in the administration on a high horse about the effrontery of individual district court judges applying the law and therefore giving remedies, I think especially of Judge Jeb Boasberg. And there was more to it, and I don't want to simplify, but I do want to sort of get into process. So if I can start with you, Congresswoman, what, as you understood it, what was prompting this hearing on supposed judicial overreach? What was the kind of game of the members of the subcommittee and the majority of calling it? And how did you, approach the kind of possibles that you as a minority member could achieve in the hearing?
Well, so of course, I guess we can start with the title of the hearing, which was,
right.
I've forgotten what their title was. We called it the Republicans' Dangerous Judicial Power Grab. They had a different title.
We can stick with yours. I can give you the formal. Kate Shaw.
I've got they called it Judicial Overreach and Constitutional Limits on the federal courts, which really stacks the decks right there.
A little bit. But that was a give, a tell, as they say in poker games. Okay.
Well, that's what we see with this majority, both this term and last term, that the hearings get called. There's an overt or blatant political push in it. This one was really interesting because it was ostensibly about the fact that so many judicial orders and in particular nationwide injunctions are being issued in cases involving this barrage of executive orders coming from the White House. And they kept saying it's unprecedented. But of course, we were making the point that it's unprecedented for a White House to do so many illegal or unconstitutional things. And thank God the courts are stepping up. So,
and we're up to what, over 100 now injunctions from district courts, Kate? We're really high. And let me just say, to simplify this, let's keep nationwide injunctions out of it. That's a more complicated issue. But you knew one thing that was happening. You could just listen to the very sage press representative of the White House, Catherine Leavitt, saying this was going to be, how dare an individual district court judge actually enjoin the elected president of the United States from applying his view of the law, right?
Correct. And then there was this subtext to this hearing. While it was ostensibly about judicial power, it also was a way to placate some of the Republican members who wanted to do more, for example, who wanted to impeach Judge Boasberg or other judges. So This was kind of, okay, if you'll sit tight and not call up your impeachment motion, we'll let you have this hearing so you can dump on judges.
And was that actually discussed? Yeah, that's right. The 7 members, I think, have called for impeachments of him or other judges, all of them getting immediate maximum contributions from Elon Musk. But was that actually somebody talked to somebody who said, will you just give it a rest on impeachments and we'll give you a hearing? Or did it just, was there that much talking?
I was not part of that conversation.
Yeah.
But that was the fairly rampant speculation. Also, the somewhat unusual nature of this hearing that included, it included 2 subcommittees, but the author of the Boasberg impeachment resolution was only on one of the committees. So they had to pull it all together in order to get him in the room.
Got it. And we had 4 sets of witnesses, I think, and some of them I think you could tell where they would be coming from.
Talking Feds is supported by the Brennan Center for Justice. In this new political era, the Brennan Center will do what they do best: defend the Constitution and the rule of law. They're prepared to fight against presidential overreach and will continue advocating for reforms to resist weaponized government, stop billionaires from corrupting our elections, and ensure every eligible American has the freedom to vote. Stay informed by visiting BrennanCenter.org.
And then, Kate Shaw. So where did you first sort of hear about this, and what was your kind of thoughts going in? You've done this before, and you know how this works, including from the White House. What was your kind of prep for it and thought about what your role as witness was going to be?
Sure. So I initially got an email inquiry from the staff of Congressman Jamie Raskin from Maryland asking if I would be available to do this hearing, which was on April 1st. And I initially said, no, I actually teach that morning and we're kind of near the end of the semester, and so I can't. And then I got a call. I don't think he would mind my saying, I got a call from the congressman who said, I know how this works. He, of course, was a very distinguished law professor himself before he was a member of Congress. And he said, you can probably reschedule that class, or I'll come talk to your class. Can we make this work? And it's a little hard to say no. And so, of course, I said, yeah, I'm sure I can find a way to make it work. So I did.
Is it going to come talk to your class, by the way?
Not this semester, because actually we were so jammed up on content we couldn't. But I am definitely going to hold him to that bargain next year. Yeah. And it was only about a week out, which was the other reason I initially said I don't think I can do it, because I've got, you want to do justice to an important topic, which is what is the nature of the judicial power and how do we know if it's been exceeded? And that's an important question. But it, I was, when called, I was happy to serve. So I just put together some hearing testimony and kind of prepped for the questions that I anticipated getting.
Right. You did put together testimony and laid it out, you have, and if I can be presumptuous, I also have this, not necessarily easy task of trying to put legal concepts, fairly sophisticated constitutional ones, in ways that, people can understand, hopefully. So I've seen that the sort of sheet you put together. Was that completely on your own? Was that in consultation with staffers? No, that was
completely. Yeah. So I just drafted it from scratch, and I did have a couple of, I think I only had one research assistant help, do some quick site checking. And I will say I was enormously benefited by our mutual friend, Steve Vladek, who put together, published, I think a day or two before the hearing, published one of his posts that he publishes under the Title I First on Substack that is just an indispensable resource. And he actually had just put together, fortuitously for me, a very detailed compilation of all of the rulings, all the suits against, and all of the rulings against the Trump administration since January 20th, crunching the numbers and I think demonstrating to very powerful effect how cross-ideological these rulings were. So you had asked about the number, Harry.
Yeah.
3 weeks ago, it was 67 rulings in
Yeah.
150 cases. The number is higher now, although I don't think quite at 100 yet. But
Okay.
he was able to show, and I was able to, obviously with attribution, to show in the testimony that these these suits have been filed across the country, and the rulings against the administration have been handed down by judges appointed by presidents of both parties. None of these suits have been filed in these single-member districts that I think we all think are subject to some abuse, and definitely were in the last administration, and that, something like 70% of the suits filed so far have resulted in some kind of preliminary relief against the government. So that does sound high, but when you drill down, the fact that 39 judges appointed by 5 presidents in 11 district courts have granted this preliminary relief, it's, I think, easier to make the case that, as you were saying, yes, the number of rulings against the administration is unprecedented, but it's because there has been an unprecedented sort of barrage of lawless actions, and the judges are appropriately responding. And so that's, I think, the thrust of what I tried to convey in the testimony and then in response to questions.
And and that continues even to yesterday with a Trump appointee issuing a really important and a new Alien Enemies Act case. I've seen this as being a matter of especially what's going to happen at the Court of Appeals and Supreme Court level, but the district courts on, pretty strongly across the board have been responsive. And it's not simply the number of orders, it's the number of really, brazen unconstitutional orders. From being at the White House, all orders have to go through the Office of Legal Counsel and really be fly-spec'd. As best I can tell, that's just not happening at all. Yeah. All right. So back to you, Congresswoman. And so there, did you have, the drill, and you could probably predict, maybe, I won't ask you to do it, but maybe even do a good imitation of the Jim Jordan questions and impression. But, the real limited ability to do much in a hearing like this, which is so theatrical, I think it's fair to say. What did you have any kind of strategic goal going in? Was it just Mary Gaye? It's your turn. See you in a couple hours, or are there things that could have gone better or worse in these kinds of somewhat staged? Theatrics?
No. When you're in the minority, you only get one witness, sometimes 2, and the other side has 3 or 4. We have, for the, being in the minority, this is now our 3rd year in the minority. We've tried to make sure that we're not buying into whatever the BS is that's being pitched on the other side. So as we go into each hearing, it's like, what do we think is important? That it's at least marginally related. We haven't completely abandoned whatever the topic of the day is, but what's important related to this? Let's get a good, solid witness in there who can help people who are inclined to understand what's actually going on, and let's pursue that. And we were thrilled that Kate was.
And who would those people be? The people outside the room? Everyone in the room is on one side or another, basically.
Oh, you were going to say on meds, but okay. Yeah. No, I think, it's kind of surprising how many C-SPAN junkies there are out there who watch, and certainly some are only looking for validation, but other folks are tuning in to say, what is going on and how can I understand that? So I think it's important to try to arm them with facts and talking points to be able to push back. So we try to do that and try to do similarly to what you try to do, which is break down some really complex questions into understandable language, as well as having a mind to the historical record.
Yeah. I hope that's what we do, or we have to change jobs. So, Kate, back to you. So you gave your sort of, I think you were probably very well oriented to the basic points you wanted to make. And, for witnesses, it seems to me, on the one hand, it's a little bit nerve-wracking to be in Congress. On the other hand, many of the questioners are not going to be so challenging. Tell us about the questioning you faced, both from the majority and minority, if it was sort of what you expected, and how you handle, as a witness, those sorts of, when you get hostile overtones, how do you sort of parry them in the most effective way?
Well, I think great questions from Congresswoman Scanlon and others on the Democratic side of the aisle that just basically said, that use some of the time to themselves talk about some of the principles at stake in the topic of the hearing, independence of judges, the value and importance of due process, the impermissibility of targeting for punishment perceived enemies of or critics of the president, whether we're talking about academic institutions or law firms. And so a lot of it was members speaking, and then sometimes inviting me to try to sort of elaborate on some of the concepts. And
did you know the particular questions were coming?
No. I talked to one member staff, not Congresswoman Scanlon's, but another member staff who gave me a general sense. It was just wanted to kind of make sure that I had seen a specific concurring opinion. And of course I had. But other than that, it was just, kind of anticipating the general topic. And then I think, obviously the more challenging questions are the ones that come from the other side of the aisle. So I was there as the lone Democratic witness, and then there were three Republican or majority witnesses. And I didn't get that many questions from Republican members, but I did get some. And I think that it's a delicate dance. You want to be responsive, but also don't want to be lured into an exchange that you're not really there to have. So Congressman Jordan did ask me at one point about, basically, does the president have the authority to keep us safe or to deport people? And I tried to be polite, but not engage on the kind of question of immigration enforcement policy, which I didn't think I was there to speak to, and nor do I have any real expertise in. But I did say the president has a lot of power to decide how to enforce the immigration laws, but also the principles of due process and the Constitution writ large are supreme. And so I did say I'm not really going to take a position on immigration enforcement. And he tried to say, well, you talk about this stuff. And I said, but about the legal dimensions, not the policy. And then he let me, he didn't try to goad me further into answering. And so I think that was hopefully a constructive exchange. And there were a couple of others, one where I did get to say, because I was asked about previous comments I'd made that were critical of judges in single judge divisions enjoining administration policy in the Biden administration. And I said, I remain pretty critical of those, but I do think that it's important that none of these TROs or temporary restraining orders or preliminary injunctions have been issued by these single judges in one judge divisions. And so I think I am still critical of those. And yet I mostly think that these orders have been correct and they're really important. And the thing I really wanted to say, and this was to the majority, right? Not to the minority that Congresswoman Scanlon obviously is part of, but I wanted to say, like, the reason it's so important that the judges are doing this is because other important players in our constitutional order have been derelict in defending the prerogatives of their institutions and enforcing limits on presidential power. And it's so important that the courts are doing this. And also, you should be too. And I did try to say that, and I think I basically got to.
Yes.
Yeah. Please go ahead, Congresswoman, because you were there. Yeah.
Going to be one of the big points, and we were thrilled that she was able to get that out. But I mean, you've been a prosecutor, so we do try to, when we have witnesses in, to do that basic witness prep. And this is what Professor Shaw was so great at, which is don't accept the premise of their question. Stick to what you know and say what you know. I mean, you can be even more assertive, obviously, than if you were a witness in a case, but don't accept the premise, because it's probably going to be when did you stop beating your wife kind of a question.
Right.
So, stick to the points you want to make and don't feel obliged to answer something crazy.
And it is trickier than it looks. I've done some, and I've also prepared a lot of judicial candidates for testimony. And even though there's a bland surface, there are a couple missteps that would swamp the whole hearing. So you never want to look like you're getting mad, even if the questions are so unfair. And there's a way that you could just step into a soundbite and otherwise fine answer, or even all testimony could be completely subsumed by. But I think pros like Professor Shaw know that drill pretty well. Okay, so the whole thing, another aspect is when C-SPAN zeroes in, it feels like Congress is totally fixing its gaze here, but in reality, what people are sort of in and out, and they're not really listening to each other. Tell us a little bit about what it really looks like, the architecture of a hearing like this in the room rather than on C-SPAN.
Sure. I mean, well, so this was a particularly large hearing because we had two subcommittees participating. So we ended up having, a couple dozen members who could participate, but I can't remember what else was going that day, but we were not the number one hearing on the Hill. There was something in oversight or some other hearing that was taking place that day. So the cameras were kind of elsewhere. People are running back and forth between hearings, so they're in and out throughout the day. I mean, this one was enough of a draw that people did show up and ask their questions. Sometimes up there texting them saying, hello, we could use another member here. But so it is, I mean, probably the most famous example of that is when we had a hearing on the 9/11 medical fund reauthorization, and Jon Stewart came. It was a subcommittee hearing, so it was a fairly small group to begin with. And then people were getting pulled in and out to go to other hearings. And he was extremely offended, which you can see why one would be. It looked like people weren't paying attention. But in fact, there was just all this other business going on around.
Yeah, there is this sausage making aspect to it when you really come close to like, wow, this is government in action. Okay, so thanks very much. And this is a really valuable opportunity to sort of probe what happens. I just want to ask both of you, including Kate, you're not just a witness, but you've worked in government and sort of approached hearings like this. Is the basic notion when you're in the minority and you're having these, I'll use the word, kind of bogus or polemical hearings, is it first do no harm? Is that about where things stand and the best you can do? Or in fact, do they present opportunities for a minority, especially if they happen to have, the law behind them, to actually achieve constructive results? And I'd like to ask both of you that. Yeah. Kate, you want to?
Yeah, sure. I mean, I certainly would defer to the Congresswoman in terms of the committee perspective, the member perspective. I mean, I would say that I think that there's no reason not to be more ambitious than just do no harm. I think that you could do affirmative good even in the minority in a hearing like this one. And I mean, I think maybe a couple of things that I felt like maybe were constructive about this hearing. So one, there was a lot of conversation about impeaching federal judges, and it was not abstract. There are a number of actual impeachment resolutions that have been introduced against a number of federal judges for no other reason than their rulings against the Trump administration. There are, I think it's still the number that as of April 1st was 7 pending resolutions, and that is a very big deal. And I think that it seemed as though some of the committee leadership actually didn't really want to talk about this because they were a little embarrassed. They were not the authors of these resolutions, but they have members who have drafted and introduced these resolutions. And so I do think that it's fair game to talk about them. And I think that it became clear over the course of the hearing that at least at the leadership level, there is no appetite for pursuing those impeachment resolutions. And that's important. And so I think that at least making them address directly these things that are pending, I thought was really constructive. And I also actually thought that some of the things that the members were saying, and maybe that I was saying about many of the administration's moves that have been found unlawful are unlawful because they invade the prerogatives of Congress, and Congress should care. Yes. And I felt like I saw maybe at a few points like that was a little bit resonating. And that's just the inside the room audience. I have no idea who in the sort of broader public was watching, but those seem to me two potentially constructive developments that could happen in the course of a single hearing. And so I think why not, sort of swing bigger than just pure defense in a hearing like this one.
I think that's right. I mean, you are absolutely right that some of these hearings are all just bogus messaging, whatever. But there are moments and there are hearings where there is actual information exchange, which, of course, is the purpose of the hearing. And that's why we try to approach it that way. If we know that, the majority's objective for the day is just to push some nonsense, we try to at least pull it back and get something constructive out of it. I am forgetting. Is yours the hearing that we had Newt Gingrich there?
Yes, he was the
Yeah,
one of
yeah, he was- right.
I just wanted to confirm. So we had a couple moments there that were really, really interesting. One of the members in the minority pressed him on whether or not he thought the president could go for a third term. And he said, no, that can't happen. So, and it was the same day or the day after that Speaker Johnson had said the same thing. So there were some nuggets there. And you're right, there were opportunities for discussion. And we do see that more in the hearing context than the markup context, probably. But there are elements of that. And we've seen a little more of it this term in some of the exchanges with Ranking Member Raskin.
Real government in action. Thank you so much, Kate Shaw, Congresswoman Scanlon, for kind of shining a light. It's a rare opportunity to think more about how it actually works. And thank you both for your very good works. And we'll hope to see you soon.
Thanks so much, Harry.
Take care.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.